Running a business shouldn't feel like surviving a software group project. One app for accounting, another for inventory, another for sales, and somehow none of them talk to each other. That's where Odoo comes in, an all-in-one business management software that brings every part of your business together, from sales and accounting to inventory and marketing, all in one powerful platform. No messy integrations, no bouncing between tabs, and best of all, no spreadsheets. Stop managing software and start managing your business with one unified system. Try for free today at odoo.com. That's ODOO.com.
Here's what she says. She says, the evidence comes directly from the things that Donald Trump has said that are, her words, so repellent and racially inflected that the majority declines to put them in print. And then she says, unlike the majority, I will.
Welcome to Law and Chaos, where the Supreme Court is awful on prisoners' rights, and the Supreme Court is awful on international war crimes, unless it's a U.S. company committing them, and the Supreme Court is awful on immigration, but district courts are holding the line. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
Well, personally, I am very happy, very excited. The weather's beautiful here in Baltimore. I've been going to the pool. I'm waiting for my next cribbage match. I've got a fun subscriber bonus episode that's getting ready to come out. Like, everything's going well, except, of course, for, the law and all of that. How are you?
I mean, I'm fine, except for the Supreme Court. I'm going to do some lovely stuff with one of my kids for their birthday this weekend, so that will be nice. But man,
that is wonderful, and that is something that we all need to get out and touch grass in all the ways.
All right, so obviously we're going to talk about what happened at the Supreme Court this week as it races to clear the deck so the justices can go on summer vacation and get paid by their sugar daddies to hang out on boats and yachts and RVs, of course. But then we will end with a more upbeat segment in which the SPLC hopes to follow in the footsteps of other cases across the country where district court judges have rejected the administration's effort to criminalize protest and dissent. But first,
dun-dun.
Docket alerts. Okay, in D.C., we have the continuing saga of the Lincoln Memorial Reflecting Pool, which has been vandalized by ninjas in the night.
Yet ninjas bearing box cutters and bags of fertilizer, apparently. I mean, if you believe the president.
In fact, I do not believe the president. But Trump claims that at least 6 people, I think 7 now, have been arrested and charged, and they're going to jail for a long time.
Yeah. Okay. For context, Trump's U.S. attorney for D.C., Jeanine Pirro, had a guy on videotape throwing a sandwich at an ICE agent, which is a crime. That guy said in public, yes, it was me. I threw the sandwich. And Pirro still couldn't convict that guy. So I'm a little bit skeptical that she's going to send anybody to jail for touching the reflecting pool.
Well, when you put it like that.
Yeah. So right now, we only know of one person who has actually been charged. His name is David Hearn. He is a 67-year-old former Olympian. His sport was whitewater canoeing, which I did not know was an Olympic sport, but sounds delightful. Anyway.
You're going to get in a canoe?
Sure, why not? Anyway, Hearn was on a 64-mile bike ride last week. That's the thing I will not be doing. And he stopped to touch the water in the reflecting pool, after which he found himself arrested.
Yeah, no matter how dumb you think things are, they can definitely get dumb.
And probably will. So Hearn is represented by my former partner, Norm Eisen of Democracy Defenders, which is involved in a lot of these anti-Trump cases. And Eisen says that Hearn will be arraigned in D.C. Superior Court, that's state court, which suggests to me he's not being charged federally, at least not for right now. He's being charged with a misdemeanor under Section 22-303 of the D.C. Code, which bars malicious destruction of property. Maybe at some point they will go to a grand jury and get a superseding indictment to charge him with a felony, but I tend to doubt it.
Yeah, so just to make that subtext into text, a felony is a crime with a penalty of more than a year in jail, and you need a grand jury to vote to indict in the cases of a felony. Pirro has had a hell of a time getting federal grand juries to vote to indict. But this is D.C., which is not a state. So she can also take cases to municipal grand juries in D.C. Superior Court, where she has had a slightly better track record of getting an indictment and not getting no-billed for whatever reason. And in U.S. District Court for D.C., that's the federal court, she also runs the risk of winding up in front of judges who already hate her and distrust her office, particularly Chief Judge James Boasberg.
But not limited to.
That may be why Pirro initially parked this, super criminal in municipal court, because she does have concurrent, overlapping responsibility for the municipal and the federal court.
Because D.C. isn't a state. I agree 100% with your legal analysis. But Liz, I think you're giving this case quite a bit more respect than it deserves, right? This is a bullshit charge. It will never go to trial. If they do actually manage to indict Hearn and anyone else who simply touched the water in the reflecting pool or even the peeling paint or whatever, that will wind up being the greatest scandal since the Broadview 6 indictments in Chicago, right? Because as a prosecutor, you would have to lie your ass off to the grand jury to get an indictment.
Yeah, it's funny because I'm on the White House mailing list. I have a weird job,
Better
right?
You than me.
I also have a Truth Social account.
Better you than me.
Yeah. So they sent out this official comm this morning of a woman who does indeed appear to be sticking her hand in the reflecting pool and peeling off a chunk of paint. But I mean, there's it's the afternoon. It's sunny. There's hundreds of people in the frame. She just is kind of reaching around, and maybe she pulled something. I have no idea whether she did or not.
Yeah.
But they've made it out in this picture. They're like, we got her, the super criminal. And they accompany it with the most deranged rhetoric. The email called it targeted sabotage by anti-American crackpots who despise a strong, proud, and beautiful country.
She didn't make the paint peel.
No, right. I mean, people are talking about this like it's the Berlin. They were talking about it was like the Berlin Wall, right? That you would want a piece of it. I mean, the paint itself was already ruined because of the algae that came from using the municipal water, which is full of phosphates, which are basically algae food.
RFK tells me that that's not real.
Jesus Christ. And then they dumped hydrogen peroxide in to kill the algae, which is like paint stripper, right? When they said you were a peroxide blonde, they didn't mean because your hair looked so good and healthy, right? That's what's happened to the reflecting pool. The paint was already peeling off in strips, but now they're going to pretend that some lady out walking around with her friends in flip-flops on a Saturday is Antifa. Good luck, friends.
I love doing this show with you. Okay. Speaking of places where that shit might work, I guess we have to talk about the horrendous sentences that are coming out of Texas. On Tuesday, Judge Reed O'Connor, frequent villain on this podcast, handed down decades in prison for protesters at the Prairieland Detention Facility in Alvarado, Texas. The demonstrators showed up with fireworks, and at least one of them had a gun.
Although everybody in Texas has a gun.
I mean, that is a fair point. When the cops pulled guns on the protesters, one of them shot the cop, which would tend to go to my point. Maybe everybody shouldn't have guns, but that's beyond the scope of this podcast. Okay. From there, the government back formulated this material support for terrorism charge for everybody who was in the group, and including people who weren't even there that day, people who just agreed with the goals of the protest and participated in organizing it. Judge O'Connor said at the sentencing that he was sentencing the defendants up to 100 years in jail because, quote, the state wants to send a message to anyone who shares a similar ideology.
Yeah, way to make it clear that this is about suppressing speech, which is protected by the First Amendment and not actual crime. In fact, much of the Fed's evidence here was that the defendants printed this anarchist zine, and that made them all a part of the conspiracy.
I mean, we have been here in the 1920s, right? But look, Reed O'Connor is very bad news. The defendants ordinarily, you would say, would get their rights vindicated on appeal, but this appeal is going to the Fifth Circuit, which is as bad, worse, better. I don't know, but it's not good news.
Yeah, and the less we say about the Supreme Court, the better. Although we actually will have a lot to say about the Supreme Court in just a little while.
Yeah. I have to say, I fear that these defendants are going to be in jail until the next president grants them clemency.
Speedily and in our own times. Amen. Okay. And for our doofus of the day.
Woohoo!
You doofus!
Let's revisit something we talked about in our blog post today. We're going to listen to Postmaster General David Steiner responding to a question from Michigan Senator Gary Peters about the proposed rule change that would allow the post office to refuse to deliver mail-in ballots to anyone not on a list of voters submitted in advance by the state.
Yes or no, if a state refuses to turn their absentee voter list over to the federal government, will the Postal Service still mail their ballots under this proposal rule?
Under our proposed regulation, no. We would tell the state that we need the manifest in order to, look, what we're asking for.
I mean, that's the answer. You would tell no. So the proposed rule basically coerces states to conform to these new requirements and hand over their absentee voter rolls or face the consequences of not being able to vote by mail. Some states, that's all they do. Oregon is completely vote by mail. If they say, no, we control the list, the states control the list, we're not going to give it.
Oregon has followed Kit 600 since the day they started voting by mail.
This is a different issue. This will be a lot different issue. You're telling these states either give the federal government this information, trust the federal government, trust the Trump administration. We'll take good care of these. And if you don't do it, you can't mail absentee ballots. You're going to make a decision that people cannot vote by mail. That's unacceptable. The states control their own elections. That's pretty clear in the Constitution. And an effort by this administration to nationalize elections and have the federal government having this information is incredibly dangerous precedent. You can imagine sharing this information with the Department of Homeland Security and using these lists for a variety of nefarious purposes. We need to protect the integrity of the voting rolls. We need to protect the separation of elections from federal government and ensure that our state and local governments are the one administering their own elections. That's what this is about.
So, in our subscriber post, we talked about Trump's effort to build a disenfranchisement machine by stealing state voter rolls, hacking the Social Security database to turn it into a supposed master list of eligible voters to compare these voter rolls against, and then having the post office refuse to deliver mail to anyone not on the list. The first two of those have been blocked by the courts because the feds are not entitled to seize state voter rolls, and the Privacy Act specifically bars the use of Social Security data for such a purpose. Also, there's no obligation for non-citizens who get a Social Security number so that they can work to tell the Social Security Administration when they become naturalized.
Yeah, and let me just unpack that for a minute. The database that they're using has that old data. It is not automatically updated when somebody who is a non-citizen is naturalized, becomes a citizen, and becomes eligible to vote.
Right. So the Social Security Administration's internal estimates say that maybe 3 million Americans right now who are in that database would be flagged as non-citizens and potentially kicked off the voter rolls, which is a tremendous number of people. And there's a lot of error because people have the same names and people live in the same, house and they have the same name as their dad and whatever. Okay, so that's a problem, and that's one of the reasons that Judge Sparkle Souknanen enjoined that last week, enjoined that use of the Social Security database. The third prong, that the mail ballots prong, is what Steiner was talking about in that clip. And he was trying very hard to claim that the proposed rule change just codified something called Kit 600, which was a booklet that the USPS put out kind of listing its best practices for mail-in ballots. And he's not lying that Kit 600 did indeed recommend barcodes and such. What he's lying about is the requirement that states submit a list in advance of who they're sending the ballots to, basically a list of their voters, and then the post office would refuse to deliver if such a list were not submitted or if there were people, that the ballots went out to who weren't on such a list. And there would be a lot of other implications of that, right? That the states couldn't send it out late because I think this list would have to go out 30 days before the election. It would be impossible for the states to comply with such a regulation if it went into effect as they intend it to next month in July. That's not really workable.
Right.
Which is why this guy is a doofus of the day, because he's lying and he's trying to say, this is what everybody always did. No, sir, it did not.
Yeah. So there has been pending litigation about this issue in two separate courts. In Washington, D.C., Judge Carl Nichols, Trump appointee, said the issue was unripe because no rules had yet been propounded, and so therefore there was nothing to enjoin but the executive order. And courts are loath to enjoin executive orders that seems to raise potential separation of powers issues, to say, oh, the president can't say stuff. Like, the president could say stuff. It's the implementation of that stuff that's the problem. Okay. That was on like May 25th. By June 2nd, however, the rules were propounded, after which Judge Indira Talwani in Massachusetts, the other case, said last Friday that now the issue was plainly ripe, and so she was going to rule imminently. And today, she did. She granted summary judgment to 23 states and the District of Columbia, entering a permanent injunction barring the post office from implementing this harebrained scheme to refuse to deliver ballots. She also enjoined the government from implementing the order to compile a list of citizens for the purpose of policing state voter rolls.
See, we can have nice things.
Indeed we can.
Okay, we're going to take a quick ad break and come back for some maybe less nice things, but important things that we do indeed need to talk about. So stick around. We'll be right back. Okay, our main story today is, of course, the Supreme Court. This week it issued 9 opinions. That leaves a backlog of 8 cases that have to be resolved before the court goes into recess. Those include the most high-profile cases that we've been waiting on for months, like Trump's power to fire executive branch employees and attacks on trans people, campaign finance limits, and, of course, the birthright citizenship case. Of those 9 cases issued this week, 2 involved largely non-political legal questions. That left 7 cases with political implications, like can the Trump administration carry out its horrible deportation policies? Can victims of international war crimes sue for human rights abuses? Can states pass even the most moderate gun control laws? And in those 7 cases, each and every one was a 6-3 decision, with all 6 right-wing justices voting as a bloc to reach their desired right-wing political outcome.
Yeah. Before we get into the specifics, I want to make something very clear. Our criticism of what the Supreme Court is doing isn't just that we disagree with the outcome in each of these 7 cases. I mean, we do. But you could argue that a few of these cases did, in fact, present interesting legal questions in isolation. The issue is that taken together, each and every one of these cases was a 6-3 decision where the right-wing majority, as you said, voted in lockstep to reach the outcome they wanted, even where doing so required applying contradictory legal principles, even on cases decided the exact same day.
Yeah.
So what I hope is the somewhat optimistic part of this, the question of what can we do, is, Liz, you and I can continue to document in public, in print, on this podcast, that this is not normal. Before John Roberts became Chief Justice, it wasn't this way. You could not predict which way the Supreme Court was going to rule just by counting up the Democrats and the Republicans.
Yeah, and if this isn't what a Supreme Court is supposed to do, then we can, and indeed should, muster the political will to fix it, push the Overton window to add 4 more justices. We have 13 federal circuits. There should be 13 justices. There's nothing holy about the number 9.
Right.
We should strip the court of jurisdiction to rule in specific cases. Congress has the power to do that, and to constrain its power to issue these shadow docket rulings, that is to interfere in the process and effectively make law without having to hear a case. The right wing has kind of framed this, or attempted to frame it, when I think they're kind of past attempting to frame it, right, for a long time.
Just calling balls and strikes.
Right. In the beginning, they sort of tried to say, like, well, we're just getting to the real law. We're, to pretend that this was a nonpartisan institution and that any effort to reform it would be meddling with sort of a holy tradition. I don't think that they pretend that now. Certainly Trump doesn't pretend that now. He tweets all of the time, like, why won't they, Amy and Brett, so disloyal. And
yeah, I put them on the court. Why won't they deliver what I want? Yeah.
Right. But even if Trump weren't saying it out loud, it's very clear now that this is not your dad's Supreme Court.
Well, speaking of my dad's Supreme Court, right? The example I keep coming back to on the show of what the Supreme Court should look like is a 1992 decision, my dad's Supreme Court. Planned Parenthood versus Casey. Look,
oh, that's not my favorite one either.
right. The Supreme Court was not great in 1992, but I want to unpack a little bit about what happened there. Right? This is, I think, kind of the permissible bounds of the shifts of the court. So the lead up to Planned Parenthood versus Casey, right-wing anti-abortion activists thought that they could play the count the Republican math, right? Like they looked at a Supreme Court that had two of the only two original dissenters from Roe v. Wade. That was a 7-2 case. They're like, okay, we got those two, and we've had 12 years of Republican presidents, right? Reagan got to appoint a bunch of justices. George H.W. Bush got to appoint a couple of justices, and they thought, okay, six Republicans plus 2 dissenters. Even if there's some, like, hey, we got this. And as it turns out, they didn't got this, right? Like the majority of those Republican appointees, the Reagan appointees on the Supreme Court, got together and crafted an opinion. And they said, look, had we been on the Supreme Court during Roe v. Wade, we would have voted the other way. But the principle of stare decisis compels us not to change the law just because we disagree with it and just because we have the numbers.
Right. And those days are over, right? There's zero accord for stare decisis here. They just make the law as they wish. So let's start off with the first set of contradictory cases. That is Cisco Systems, Inc. versus Doe and Exxon Mobil versus Corporación CIMEX. Cisco is, of course, a $500 billion company based in California. In its own words, it's a worldwide technology leader that securely connects everything to make anything possible, which is not at all big brothery. They have probably made the router you use to connect to the internet. They also designed and built a mass surveillance system for the Chinese Communist Party called Golden Shield, which is used to identify and track thousands of Falun Gong and other religious minorities, often leading to their arrest and imprisonment.
Yeah, and torture. And so if Cisco aided and abetted torture, that would be an international war crime. And so a group of anonymous plaintiffs, members of the Falun Gong, victims of torture and their family members in cases where they'd been executed, sued Cisco in U.S. federal court under what's known as the Alien Tort Statute. That's 28 U.S.C. Section 1350. That law dates back to the very first Congress. It was passed in 1789. It is one sentence long, and it says, the district courts shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. And as recently as 2004, the year before John Roberts joined the Supreme Court, in a case called Sosa versus Alvarez Machain, the Supreme Court ruled unanimously that statute, the Alien Tort Statute, created an implied right of action for non-citizen plaintiffs to sue defendants in U.S. courts for violations of international law. And again, we're just talking about standing here. We're not saying that Cisco definitely aided and abetted international torture. We're saying you can make that claim in court. You can prove that you have the opportunity to prove those allegations if true.
Yeah, and this week, the 6 Supreme Court justices said, that's not actually how we want it to be. And so Justice Amy Coney Barrett was tasked with going back and retconning a justification. Here's what she said. Those 230 plus years of how we've understood the Alien Tort Statute are wrong because the law doesn't create an implied right of action after all, even though it sort of sounds like it does because it gives a court jurisdiction over it. In her view, a jurisdictional statute isn't enough because if there wasn't an express right to sue that the first Congress would have recognized in 1789, you don't have a right to sue today. Why would the court create jurisdiction if you weren't allowed to sue? That's left as an exercise for the reader. Then she reasoned because the first Congress wouldn't have recognized a cause of action for a foreign national to sue a U.S. company in the U.S. for developing software that aids in mass surveillance that will lead to people being picked up, arrested, and tortured. The plaintiffs here lack standing. Specifically, Justice Barrett said that in cases that by their nature implicate foreign policy, judicial authority to recognize causes of action is necessarily narrow. It has to be explicitly enacted by Congress.
So that's a terrible result. But it's also impossible to square with the Supreme Court's decision on the same day that you flagged, Liz, in Exxon Mobil versus Corporation CIMEX. In that case, the question was whether Exxon Mobil can sue a company owned by the government of Cuba in federal court in the United States over the Cuban government's seizure of Exxon Mobil oil assets back when Fidel Castro assumed power in Cuba in 1960. And Cuba said, wait a minute. we as a nation have sovereign immunity under the Foreign Sovereign Immunities Act that says you cannot sue a foreign government. And Exxon Mobil said, no. We have a right to sue under something called the Helms-Burton Act of 1996. That is 22 U.S.C. Section 6082. That law says that a U.S. national can sue any person that traffics in property confiscated by the Cuban government.
So the question here is whether the Cuban government itself counts as any person and whether operating its own seized property counts as trafficking. And for the past 30 years, and according to common sense, the answers to those questions have been no, obviously not. If Congress had intended to abrogate the Cuban government's sovereign immunity, it would have said so. And that's backed by the legislative history around Helms-Burton, which shows that what Congress wanted to do was to allow Cuban expats living in the U.S. to sue people who stole their stuff in Cuba and resold it. That is what trafficked means.
Obviously, that question, right, of whether Exxon Mobil can sue the Cuban government, to go back to quoting the language you quoted from Justice Barrett, by its nature implicates foreign policy, right? So if Justice Barrett had been articulating a real principle of law, we would expect the Supreme Court to at least put Exxon Mobil in the same position as the Falun Gong plaintiffs, right? To say, sorry, it's foreign policy, so we as a court cannot read an expansive interpretation to recognize causes of action into Helms-Burton. If Congress wants Exxon Mobil to be able to sue the Cuban government, it can explicitly pass a new law letting it do that, but until it does so, our power is constrained.
Right, and you can tell from the setup here that Exxon Mobil came out the other way. It does get to sue the Cuban government, even though Congress never explicitly abrogated Cuban sovereign immunity. And yes, this opinion was written by Justice Kavanaugh, but Justice Barrett and the other conservatives all joined word for word. None of them even wrote a concurrence. I mean, let's read this part here. It's especially galling. It says, the Cuban government defends and the dissent assert that Congress could have more clearly displaced the Foreign Sovereign Immunity Act if it wanted to do so. That's true, but this court's precedents repeatedly emphasize that Congress does not need to use magic words to abrogate sovereign immunity, which is amazing from the assholes who gave you the major questions doctrine and the non-delegation doctrine. Just like, I mean, all that stuff about elephants hiding in mouse holes. Not today, friend.
Yeah.
So if victims of international human rights abuses want to sue an American company for aiding and abetting those abuses, Congress must use magic words, no matter how many recent previous cases you can cite. But if Exxon Mobil wants to sue Cuba to recover its oil profits, no, that's fine. We can infer it from past precedent.
As you said, Liz, this is no longer a court. This is a policy-making body. I like how Justice Sonia Sotomayor put it in her dissent in the Cisco case. She says, today's decision marks another low point in this court's esteem for its precedents. It is yet another notch in its belt, unabashedly remaking the law in its preferred image.
Yeah, I keep thinking about these internal memos. We talked about this in episode 222. They were these Supreme Court pre-decisional back and forth that were leaked 3 months ago. I think it was in the New York Times. And they showed Chief Justice Roberts in 2016 going out of his way, kind of inventing the shadow docket as a policy tool, because he said, if we let this go through, this environmental regulation decision, it will really hamper those coal plants style, and then they won't build plants or something like that. And we cannot possibly let that happen because that is not our preferred policy outcome. And it showed that he was never really calling balls and strikes. I mean, not that it was a surprise even by 2016, but it showed him reaching down to make policy and not even waiting, right? Like these decisions that came out today were not to say better, but they were at least within the Supreme Court's own rule system. This showed him reaching down and making policy, which he's done in so many of these cases by reaching down and staying orders before they can be heard by the appeals court, right? And if lower court orders, in the normal course of things, a lower court would issue its ruling, and that ruling would hold until it was heard and overturned by the Supreme Court, because the Supreme Court's not a court of original jurisdiction. And here, the Supreme Court kind of showed its hand. saying, we just want to make policy. And now they've got 6, and they are making all of the policy.
And they are making that explicitly to aid fossil fuel company, right? Like that's a through line from those memos. That case was West Virginia versus EPA. That was Justice Roberts saying, look, if we just wait for this to wind its way through the court, then it's going to reduce coal production in the power sector for, he says it's going to go down 2% the next year and 4% the year after that. And he used the line, solar plants are not built in a day, in his memo explaining, that's not a legal argument. That is a please don't hurt the profit margins of Exxon Mobil.
Right. And here we have the same with Cisco.
And that's right. The only way to reconcile the holding in Cisco and the holding in Exxon Mobil is to note that in both of those cases, in all of the cases involving Chief Justice John Roberts, the giant corporations win, the individuals that they hurt lose.
Okay, we're going to take a quick break, and we will come back to talk about this same level of contradiction when it comes to the court's immigration decisions.
And we're back. This week, the Supreme Court also issued 3 immigration decisions, each of which blessed the Trump administration's deportation policies. Again, all 3 were by a 6-3 margin, and all of them relied on contradictory logic as to how to read Congress's intent when Congress passed the immigration laws.
So let's start with Blanche v. Lau. This one was about lawful permanent residents, that is, people with green cards. 8 U.S.C. Section 1101 says that lawful permanent residents can go home, and when they return to the U.S., they aren't supposed to be stopped at the border and treated as an applicant for admission because they've already been admitted. The law does have 6 very narrow statutory exceptions, and one is if the green card holder has committed an offense involving moral turpitude.
Yeah. So now let's talk about this specific case. Muk Choi Lau had been a lawful permanent resident of the United States since 2007, nearly 20 years. He went home to China. When he returned to the United States, he was admitted, but then he was subsequently convicted of violating trademark law. No idea how that's a crime of moral, but okay, right? After that conviction, the Trump administration initiated deportation proceedings, and they argued that that subsequent conviction meant that Lau should have been stopped at the border and considered an applicant for admission. Now he's guilty of a crime of moral turpitude, so it's okay for us to deport him. And Lau said, no, wait, that's not what the law says. Section 1101 is in present perfect tense, right? It says has committed a crime, right? That's the tense that you use for things that happened in the past but have a connection to the present. So you have to have committed the crime of moral turpitude in the past, and the border officer, when you come back into the country, must then classify you as an applicant for admission under those exceptions in the present. And by the way, Liz, you said there are 6 exceptions to the law. Those other 5 exceptions in the statute are all in present tense, right? So it's just obvious that the intent of that law was meant to apply to what the border officer does when you as a green card holder re-enter the country, right? Like it was never meant to allow the government to retroactively reclassify somebody after the fact. Congress clearly did not intend to delegate that level of discretion to the executive branch.
Right. To be clear, what the Trump administration did to Lau was to initiate deportation proceedings and then during the proceedings use his supposed crime of moral turpitude to back formulate this justification for retroactively revoking his status, because they could have revoked it at the border. And the majority said, don't sweat the sequence of events so much. If he committed the crime, he would have been ineligible. So that's good enough.
Okay. So if we are to derive a principle from Lau, it would be that the tense of a statute shouldn't be read to limit the delegation of authority from Congress to the executive branch when it comes to immigration. Okay. You know where this is going, right? Because on Thursday, the Supreme Court ruled in Mullin versus Otro Lado that tense was actually the most important thing in an immigration law statute if it's about the provisions of the law that are meant to help people. Specifically, we are talking about 8 U.S.C. sections 1125 and 1158, which govern requests for asylum.
Section 1125B says that if a non-citizen who is arriving in the United States lacks valid travel documents, that person should be immediately turned away at the border unless they express an intent to apply for asylum or a fear of persecution. If they express that desire, the officer, quote, shall refer the applicant for further processing. And what the Trump administration has been doing is stationing Border Patrol guards to physically block asylum seekers from setting foot on U.S. soil, and then claiming that because they didn't touch base, the government doesn't have to process their asylum applications at all because they've never been in the United States.
And now, all of a sudden, that same 6-3 majority that said, yeah, don't sweat the tense of the verb, man, when it comes to returning green card holders, found that the tense of the word in was absolutely controlling when it comes to asylum applicants, right? Like if you put up your hand and you stop them from setting foot on American soil, then they haven't been in the country. And just as with the tension between Cisco and Exxon Mobil, I cannot see how you can square both of these cases other than noting that they both reach the outcome that the Trump administration wants, which is more deportation.
And that's the prism through which we need to talk about the highest profile decision which came out today. That's a case called Mullin v. Doe. It involves temporary protected status, or TPS, for hundreds of thousands of Haitians and Syrians living in the United States. In general, TPS is a humanitarian program Congress created in 1990 under Republican President George H.W. Bush. And it reflected a bipartisan consensus that we, as a nation, did not want to deport people to countries that were dangerously unsafe, either due to natural disasters like earthquakes and floods or war zones. If a country was designated as too dangerous for its nationals to return to, those nationals could qualify for temporary protected status, which let them live and work here legally. Haitians were designated in 2010 after the Haitian earthquake, and Syrians were designated in 2012 because of the Assad regime's brutal crackdown on civilians. Those country designations are subject to periodic review, I believe, by the Secretary of the DHS, the Department of Homeland Security, to see if the conditions have changed on the ground and if it's safe to deport their nationals. But for these Haitians and Syrians, that's who is at issue here, or many other groups of foreign nationals, they are routinely renewed and have been renewed for decades, so that what you have are people who have been living here and abiding by the law and being good neighbors and law-abiding residents for decades.
Yeah, and for whom sending them home would be a humanitarian crisis. In some cases, a death sentence. We're going to actually talk about some of the plaintiffs in this case. In his second term, Donald Trump has terminated every single TPS designation that has come up for review, not just Haiti and Syria, but 13 total countries. And lower courts uniformly blocked those decisions, right? Because they were not the process of rational deliberation and debate. That's what is required. They're the result of racist policies dictated from a racist president and his racist actors.
So the administration asked the Supreme Court to stay all of those injunctions. And actually, it wasn't a uniform result. They allowed the Trump administration to terminate TPS for Venezuelans, but then they blocked or allowed the lower court stay to hold in a case involving Haitians and Syrians. That's what one was heard today. So for a few months, Haitian and Syrian nationals got a reprieve while the court issued expedited briefing and argument.
That reprieve ended today. The Supreme Court reversed the lower court injunctions, holding that the Haitian and Syrian TPS holders were unlikely to succeed on the merits of their claim challenging that reversal, that they were being deported because of race. And to make this clear, I want to read you at some length from both the majority opinion and then from the dissent. So here's how Justice Alito characterizes the administration's decision to revoke TPS status. It says, in support of their claim that the termination of Haiti's TPS designation was based on race, respondents cite statements made by the president and former DHS Secretary Kristi Noem. The president's comments fall into four main categories. First, many express strong objections to the immigration that this country has experienced in recent decades and to many of the immigrants who have come here. Second, some statements express great displeasure with TPS. Third, some statements broadly denigrate the countries for which TPS designations have been granted, including Haiti, portraying them as hellish places in which to live. And fourth, some statements malign Haitians who have come to the United States. None of the cited statements by either the president or the secretary was overtly racial, and in substance, all expressed policy views that could rest on race-neutral justifications.
No, they did not.
Yeah. And now we're going to turn, right? So first, that opinion elides the operative standard for review, right? Like, this is not a de novo question of first impression for Justice Alito, who wrote this opinion, to kind of like decide based on his vibes, man. Like, in all of these cases, all of the lower courts found that the decision to terminate TPS was made on the basis of racial discrimination. Those lower court findings are primarily fact findings.
Right.
And that means that the Supreme Court is supposed to defer to those factual findings unless they were, the standard is, clearly erroneous. And the way in which that gets applied here is that means that the burden is for the administration to show that it is not plausible that it was motivated by race, that those decisions were motivated by race. So with that in mind as kind of the legal background, here's how Justice Kagan in dissent, and again, I just want to emphasize, Justice Kagan is by far the most centrist, the most moderate, the most small c conservative in temperament of the three real justices left on this court. Here's what she says. She says, the evidence comes directly from the things that Donald Trump has said that are, her words, so repellent and racially inflected that the majority declines to put them in print. And then she says, unlike the majority, I will. Here's what she says. Haitians are eating the dogs. They're eating the cats. They're eating the pets and other things too that they're not supposed to be. And Haitians in the United States probably have AIDS. And Haiti is a shithole country, which is filthy, dirty, and disgusting. And Haitian immigration is like a death wish for our country. And Haitians, along with some others, are poisoning the blood of our country. And why is it that we only take people from shithole countries like Haiti and Somalia? Why can't we have some people from Norway and Sweden? Those are all things President Trump has said. Justice Kagan continues. The majority briefly replies that those remarks are not overtly racial, but it is hard to know what that means. Haitians are black, Norwegians and Swedes not so much. The references of filth, disease, and primitiveness are shot through with racial stereotypes and tropes. It is hard to imagine the statements being made today of any white community. These statements fairly shout in their racial undertones and overtones alike that race entered into the president's resolve to remove Haitians from this country.
Yeah, so by the time you hear this show, real people are likely already on, as Justice Kagan put it, the next plane. That includes people like the plaintiffs in this case, one of whom was a Haitian man who's been here 15 years researching Alzheimer's disease. He has type 1 diabetes, and sending him back to Haiti, which has a much weaker healthcare infrastructure, is going to make it very hard for him to get what he needs to live. And that's not just an unavoidable consequence of a neutral application of the law. It is the outcome. That is what this administration wants to happen. I can say that there is already kind of a mild freak out in places like Florida over what could be the decimation of their labor force, because there are a tremendous number of Haitians and Venezuelans in Florida. And if the administration deports all of them, as it now has been told it can, then that will cause serious distortions to industries in which they are employed. And I want to go back to, we talked during the campaign about Trump saying that they were eating the dogs and cats, the Haitians were in Ohio. These are communities that have been settled by migrants, a lot of them with temporary protected status. And if we throw them all out, those communities won't have any people, right? These are places in the Midwest. I mean, there was a lot of coverage at the time about how this community in Ohio had been losing population. And then when Haitian families moved in, it stabilized these dying communities. And now that stability is going to be gone. So it's a tremendously sad outcome, much sadder for the victims of this. But it's going to be sad for the country, of course, to lose all of these good, important people who have been part of our community for so long and on whose labor we rely. So,
yeah.
Okay.
I may talk in a future episode about the Supreme Court's religious liberty decision. It's called Landor versus Louisiana Department of Corrections. But it's another example of this inconsistency. This was an individual who was a devout Rastafarian who has taken what is known as the Nazirite vow not to cut the hair on his head. He was in prison in Louisiana. There's a binding Fifth Court decision that says that state prisons have to respect that request, have to accommodate those who have taken a Nazirite vow. And as he was about to be transitioned to a new state jail, Landor took a copy of that decision with him, showed it to the guards, who then threw it in the trash. He and another guard took Landor into another room, handcuffed him to a chair, held him down, forcibly shaved his head. And the Supreme Court said, well, based on our interpretation of the operative statute, we're not clear that you have a cause of action here. It's there's a lot that we could say, but that will, I guess, have to wait for another show. That was another 6-3 decision, another contradiction, another, Rastafarians are weird, so all of a sudden the Supreme Court that cares so much about religious liberty cared very little in that particular case. Okay, we will be back with hopefully a more optimistic segment after our last ad break. And we're back. Okay. Let's end on a hopeful note, because we've talked about how the Supreme Court is a dumpster fire, but we've also talked about how district court judges are holding the line. They're making a real difference in real cases. And one area where they've been particularly effective is in checking the administration's efforts to criminalize protest and dissent.
Okay, so let's talk about the criminal indictment of the Southern Poverty Law Center in the Middle District of Alabama. The SPLC is charged with having criminally misled its donors and defrauded banks. We discussed in episode 232 all the ways that this indictment is bullshit. On May 26th, the SPLC moved to dismiss the indictment on grounds of vindictive prosecution, and now that motion has been fully briefed. Andrew, you said that you think they have a real shot at winning here.
I do, and I think in light of recent evidence that was uncovered in discovery, that the reply brief was particularly strong. But before we get there, let's set the stage. Let's talk about the legal standard, because before 2025, courts basically never granted motions to dismiss for vindictive prosecution. And that's because those claims tended to fall into two broad buckets. The first were cases in which prosecutors tried to get defendants to plead guilty without a trial. They're plea bargains, and up to 99% of criminal cases in federal court are resolved by plea. But sometimes, when defendants would refuse to take the plea deal, refuse to plead guilty, force the prosecutor to try the case, the prosecutor would retaliate by adding a bunch of new charges, Say, oh, you're going to make me go to court? Fine. When I win, it's going to be way worse for you. And by and large, those defendants lost on their motions to dismiss for vindictive prosecution. And the reason is you don't have to plead guilty. And if you don't, the prosecutor can then choose to charge crimes that they didn't charge before. So that's kind of bucket number one, pre-trial vindictiveness.
The second bucket is post-trial vindictiveness, and that's when the government takes you to trial and gets a conviction. But then you win on appeal and you get your conviction thrown out and you get a new trial. And then the prosecutor does the exact same thing as the first bucket by adding a bunch of new charges in the next go around, except that this time these kinds of motions to dismiss are far more likely to win. And that's because you do have a constitutional right to appeal your conviction. And so the same kind of prosecutorial retaliation, which is okay in the abstract before the trial, it's forbidden afterward.
Yeah. And I'm not sure I buy that distinction, I think you have a right to refuse a plea deal as well. But okay, there is at least an articulable principle in the cases, That is, if you can prove that the vindictiveness, that the retaliation is in response to you exercising, this is the language of the Supreme Court, a fundamental constitutional right, then you can get your case dismissed for vindictive prosecution.
Post-2025, we have seen a different kind of vindictive prosecution, and that is when the Department of Justice goes after the president's enemies. We've already seen two defendants win on their motions to dismiss on those grounds. And the first was Jay Carey, who burned a flag in D.C. to protest Trump's executive order ordering the Justice Department to prosecute flag burning. Obviously, flag burning is protected speech. So the Justice Department charged Carey not with flag burning, but with a misdemeanor for setting a fire in a public park outside of a designated receptacle, by which they mean a grill.
Right.
Carey said that the charge was obviously bullshit and was retaliating against him for his exercise of a constitutional right to speech, i.e. flag burning. And his case was assigned to Judge James Boasberg, who ruled that Kerry had made out this prima facie case of vindictiveness and who set an evidentiary hearing to investigate his claim, right, which is that what happens in these vindictiveness cases is that once you have kind of rebutted the presumption that it's a legitimate prosecution, it flips and the prosecutors have to prove that they're not being vindictive, at which point the government was like, no, see ya, and they dropped all the charges against Kerry with prejudice, meaning they couldn't be rebrought because they couldn't come in and say, oh, no, we definitely, didn't arrest this guy because 5 seconds before Trump had said that we should all lock up anybody who burned the flag.
Yeah. So Judge Boasberg's decision in Kerry paved the way for Kilmar Abrego Garcia. He made a similar showing in the Middle District of Tennessee with respect to his human smuggling charges. That time, the government actually did go through with the evidentiary hearing, but lost because the evidence clearly did not rebut the presumption of vindictiveness. I should say the administration has appealed that case to the Sixth Circuit, but the standard for review on appeal is clear error, as we've talked about before. It's a factual finding. I think that appeal is for show.
Yeah, I've said it here on the show before. I do not think that the government has any interest in going to, obviously they're not going to go to trial because that case is gone. And I think that at some point they're going to give up and just deport Abrego Garcia to Costa Rica. That's where he said he wants to go. The country will accept him. They're just waiting until we all get distracted and then they'll just do it.
I think that's exactly right. Okay, so that's the baseline of what vindictive prosecution looks like now. Now let's talk about the SPLC's case, which seems to me to be in pretty much the same situation as Kerry and Abrego. And thanks to Discovery, they've added newly discovered evidence in their reply brief that made what I thought was a meritorious case even stronger. So let's talk about that. The SPLC runs what's called the hate map. That is a publicly available database that designates certain organizations as hate groups. And right-wing groups like Moms for Liberty, Focus on the Family, Turning Point USA, the Alliance Defending Freedom have been really mad for about the last decade that they're on the same list, they're on the same hate map as the KKK and the Aryan Nation.
So in August of 2025, those groups sent Stephen Miller this pissy letter complaining about it. And coincidentally, it turned out the FBI's incident summary recommending that the SPLC be charged just so happened to match half a dozen phrases from that letter word for word. And those are not just common turns of phrases that you might dismiss as a coincidence. They're very long, specific phrases like, quote, more of a partisan progressive hit operation than a civil rights watchdog, and, quote, a willful deception designed to scare older liberals into writing checks to the SPLC.
Yeah. And so that first piece of evidence from the incident report, it is just not plausible that the FBI happened to use those exact same sentence constructions, word for word, the exact same adjective, right? That you can infer, and I think the court will, that this was Stephen Miller telling Kash Patel to go after the SPLC and Kash Patel just repeating it verbatim in his incident report. Okay, that's piece of evidence number one. The second piece of evidence I think is even more damning, and that is that FBI incident report begins with this numerical code that the FBI assigns internally based on the type of investigation that it is. There are over 100 of these codes, like 7 for kidnapping, 41 for explosives, 81 for gold hoarding, and 117 for criminal investigations into violation of the Atomic Energy Act of 1946. Okay. Anyway, there are a couple of different prefixes that might apply for a real investigation into financial crimes, which is, remember, what the government has told the court that the SPLC was charged with, right? Defrauding its donors and defrauding banks. But this does not begin with any of those prefixes. Instead, it begins with the prefix code 44, which is for civil rights, racial violence, or discrimination. And that seems to corroborate the evidence that the SPLC presented in its motion in the first place, that this was egged on by civil rights chief Harmeet Dillon, who publicly said that the indictment was personal for her. So again, it kind of looks like there's a prima facie case that this was retaliation against a group that was classifying friends of the administration in ways that they didn't like, and that they disguised it as financial fraud in order to hide the fact that it was retaliatory.
Yeah, here's Harmeet Dillon telling Newsmax that she feels vindicated by this indictment because you can't be an effective cultural warrior if the SPLC hasn't targeted you.
Well, the SPLC indictment by our criminal lawyers here at the Department of Justice is truly earth-shattering because it rips away the veil from the facade of the Southern Poverty Law Center being this venerable organization that fights discrimination based in the Deep South. What we have found is that that kind of discrimination in America today is actually in very short supply. So for SPLC to continue to fundraise off of that premise, they had to manufacture it themselves. And this 11-count indictment shows a paper trail of numerous payments to some of the most hateful groups in America, which have almost no presence, really. The Ku Klux Klan and, Patriot Front and these other groups that a lot of us suspected, because, I'm a longtime conservative. You look around and I don't know any people like this or encounter them or see them, and yet suddenly they're popping up all over the place, and SPLC fundraises off of them. Beyond that, Biden campaigned off of defeating Republicans because of this false narrative. And so I think you're just seeing the beginning of this, and I think that you're seeing the DOJ start to pull on a thread that's going to go way deeper and end up ensnaring a lot more people than the ones just than what we've seen in this indictment.
I mean, Joe Biden used this as an excuse. It was a fake excuse. It was BS. But he said this was the reason that he ran for president was because of Charlottesville, which was heavily funded by the SPLC. And again, like you said, this is in short supply. This brand of racism, this white supremacy of a darker history of this country doesn't really exist in any great form anymore. But it is paramount to the mission of the SPLC and to the NAACP to make sure that people think that it is, because that's the survival, I think, of the Democrat Party. If they don't have a villain, if they can't claim there's a victimhood in this country, what do they have? What do they have to run on without it? I want to talk a little bit more about the Southern Poverty Law Center. They actually expressed concern over your nomination for your position, saying your record raises serious questions about your commitment to protecting the civil rights of Black and brown communities, as well as the LGBTQ plus community. Adding, throughout Harmeet's career, she's been involved in more than a dozen lawsuits across the country that tried to restrict people's voting rights and defended discriminatory redistricting. What's your reaction to that?
Well, I think I'm vindicated by this, frankly. And frankly, if you're a conservative today that the SPLC hasn't gone after, I'd have some questions about you, because how effective are you as a culture warrior if they think you're benign? So I've never done any lawsuits involving restricting anybody's voting rights. But the left definitely thinks that if you want one person, one vote, and all those votes to be American citizens, that that's some kind of discrimination. Like, what does that say about them? And the other attacks, I mean, apparently I'm the wrong kind of brown or Black person. And so that's kind of racist in and of itself. But look, at the end of the day, I've had a lot of journalists, friends, Andy Ngo, clients, and groups that I've represented who've been targeted by the Southern Poverty Law Center. I think that, to me, this is very personal. They've taken square aim at the First Amendment in this country, a value that I cherish and have dedicated my entire 33-year career to fighting for. And it's about time that we see some accountability. But look, I think this is just the tip of the iceberg. I think you see a lot of these protests, these ICE protests, funded by Neville Singham and other people like that. You're seeing foreign funding for a lot of the disruption in America because we don't have organic disruption. This is the best country on earth. People love to be here. Like, what is there to be upset about? My God, it's such a blessing to be here in this country every day.
Yeah, I'm not sure I want the head of the Civil Rights Division to think of herself as a culture warrior. In fact, I'm quite sure I do not. Okay, so the DOJ doesn't really dispute any of this. Instead, it offered a novel theory about vindictiveness. It says that the only things that count as a protected right are the kind of rights you exercise after you've been indicted. That is, those two buckets of claims are the only permissible vindictiveness claims. And in other words, the government claims that you can't be vindictively prosecuted in the first place for exercising your First Amendment rights. Those aren't the kind of rights that count. And if you're wondering how that squares with Kerry and Abrego, well, no, it does not. So the government just says flat out that those cases were wrongly decided and should be ignored by the court in Alabama.
Yeah, two things. So first, there is no case law that says what the government claims. They've kind of cobbled together these out-of-context quotations in an area that, is rather lightly litigated. But even then, there's an 11th Circuit case that in dicta suggests that defendants can indeed prove pretrial animus, right? That is, that the vindictiveness came for something that you did before you were charged at all. And look, that has to be the law, right? Like, the government is claiming that it is free to punish its political enemies and that there's nothing anyone can do about it, right? Like, here's how the SPLC's lawyers put it in their reply brief. They said, imagine a progressive foreign policy think tank that criticizes President Trump's war against Iran. The Justice Department then indicts the think tank for tax fraud, having nothing to do with the critical piece. A few days later, Trump announces that the think tank was indicted because the op-ed was intended to help defeat the Republican Party candidates in the upcoming midterm elections. Under the government's proposed standards, the think tank would have no vindictive prosecution defense as a matter of law because it was not prosecuted for exercising a legal right during litigation. No precedent supports this bright line rule, and this court should reject it. And I think the court will.
Okay, I hear all that, and I think that you are right as a matter of law, but I do want to temper expectations here because this case is in front of a Trump appointee. I believe the judge's name is Emily Cootie Marks, but maybe I'm confusing that with a magistrate. But I know that it is in front of a Trump appointee in Alabama. And so I think that there may be political realities here. Like we talked earlier in the show about the difference between what happens in a real court, like in Massachusetts in front of Judge Talwani, or in Texas in front of Judge Reed O'Connor. And I'm not going to slander this judge in Alabama by saying that she's Reed O'Connor, because I think that would be a slander.
Yeah, right.
I have no reason to think that she is. But I also think I really do want to temper expectations. We do live in a world where the judiciary has been horrendously politicized. So while I think that you are right, and I think that this is an indictment which will never succeed in convicting anybody, I am not sure that they're going to get out the way that Abrego was able to get out at this stage in the proceeding. But you do certainly make a strong case, sir.
I mean, very few trial judges want to be overruled by the circuit court that sits above them. And the 11th Circuit has not been the 5th Circuit. So I hear you. I'm glad we are tempering expectations. I'm gonna hold out some hope, and we will see what happens.
Okay, that's going to do it for us. Thank you guys so much for subscribing and supporting the show at lawandchaospod.com or patreon.com/lawandchaospod, or leaving us a 5-star review on your podcast platform of choice. I know this was a rough one, and next week we'll have more Supreme Court decisions. I expect the birthright decision case will come out in a better way, but we will not forget that the Supreme Court is an illegitimate institution. And just because that they decide that the 14th Amendment just this once says what it actually clearly says doesn't mean that we should live and agree to live in this kind of political system. 13 justices for 13 federal circuits, D.C. statehood, Puerto Rico statehood, mark it. That's going to do it for us. Have a lovely weekend. See you guys.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Up to Media, LLC, all rights reserved.
You know that music? That's the sound of shopping for car insurance the old way. Life's too short for that. Jerry makes car insurance easier. Open the app, answer a few questions, and Jerry pulls up to 20 quotes from top insurers. Then choose and switch right in the app. No re-entering your information. No saxophone solos. And Jerry keeps checking rates for you. So you're not back on hold 6 months from now. Visit jerry.ai/Libsyn today.